address primarily access issues. When he was here at the University of Missouri, he was legend for many reasons. One of which was as director of the Freedom of Information Act program here, and served journalists all over the country, if not all over the world, on these issues. And so we're especially fortunate to have him back. And as an old friend, it was delightful for me to be able to share a bench with him. So, Charles,
thank you,
Richard.
It's delightful to be back. I made it through the zombie apocalypse that is Atlanta, and took off without any difficulties at all last night, which I found to be a minor miracle given the apocalyptic state of the airport as I was leaving. So I think fortune was on my side. So it's always good to be back. Spent 14 wonderful years here, and as many of you know, left in July to move to the University of Georgia. So it's always nostalgic to be back at a place that you love as much as I love the University of Missouri. I told Richard beforehand, by way of apologies, and several of my former students are in the room, and hi to you all. It's probably no great surprise to you. I told Richard I'm going to bitch a little while, and he said, "Well, of course you are," because that's kind of what I do. But I thought, given the sort of macro conversation today, that I would bring to light a couple of things that I think are in the periphery of today's conversation, but haven't been brought into stark relief, and I think need to be talked about. One of them stems very directly from my time here at Mizzou as Executive Director of the National Freedom of Information Coalition. I spent most of my tenure here involved in the freedom of information movement at the state level. Spent a lot of time at the federal level as well, just through my research interest, but it's really at the state and local level that I did most of my advocacy work here. So I certainly want to talk a little bit about that. It's always a pleasure for a dean to come and think and talk about non-deanly things, like my academic research, which now, 8 months later is a distant memory. I have wistful memories of writing and thinking about things. So it's good to be back and do that. What do deans do all day? What I've learned that we do is worry. That's largely what deans do all day. So I'm going to share with you my worries when it comes to what we've been talking about today. And I have several worries and then some thoughts maybe in reaction to them. I've been spending a lot of time, I got sent a copy of Dean Starkman's excellent new book, The Watchdog That Didn't Bark, The Financial Crisis and the Disappearance of Investigative Journalism. I think the title's a little overwrought, frankly, but I'm a few dozen pages in and I'm moved by the central thesis of that book. Last night on the airplane, I was flipping through my sort of reading pile that has grown on my desk, and so I grabbed all these magazines, among them a Columbia Journalism Review. Actually, I'm impressed. This is the Columbia Journalism Review from January, February 2014. I was worried that it was, July 2013, because I have a stack about this tall. But this one is actually rather current, and it's got an excerpt from Dean's book in here. I would highly recommend this book to anybody. He's a veteran reporter, got great chops. He's a really good writer. And there are a couple of things in here that just leapt out to me. One is a passage, well, I'll just read it to you. Now's a good time to consider what journalism the public needs. What actually works? Who are journalism's true forefathers and foremothers? Is there a line of authority in journalism's collective past that can help us navigate its future? What creates value, both in a material sense and in terms of what is good and valuable in American journalism? He then goes on in the book and in this excerpt to categorize journalism as a war between two competing strands, what he calls accountability journalism and access journalism. I won't spend a lot of time defining them, but you can kind of get that accountability journalism is checking up on the powerful, monitoring and holding accountable government officials, what I would call public affairs journalism. Access journalism is getting close to and rubbing shoulders with people in power to tell us about them. You may not be surprised that Dean Starkman has nothing but commendation for access journalism while praising accountability journalism. But I do find this really interesting. Because my overarching fear, something that's really been concerning me when I was in the professoriate and continues to concern me, is that the agents of accountability, and Adam certainly referred to this too at the state and local courtrooms, legislatures, the agents of accountability, those people that we knew had their eyes and ears on the local level governance of this country, are rapidly disappearing. It's not too dramatic to say that there are not only courtrooms, but state houses in this country, the reporting around which has diminished to the point at which there are entire days that go by in which laws are made, resolutions are tabled, debates are held, and no one, absolutely no one in the business of reporting is ever in the room. I got a call from a friend not very long ago who was at a federal district court in the state of Georgia. There was a trial going on, a really tantalizing corruption trial, including a large corporation, and he called me in a mild panic. He used to work with me in the newspaper in Georgia, and he said, "Charles, you're not going to believe this." I said, "What?" He said, he gave me the sort of fact pattern of this trial, and the plaintiff and the defendant. I mean, these are all incredibly newsworthy people. And then at the end of it, he said, "I'm in the courtroom because I live nearby and I'm a gadfly, so I just went." There's not one single reporter covering this trial. No one. It's taking place in a vacuum. You may be wondering whether or not that's inherently a bad thing. Well, what difference does it make? Well, I think it makes all the difference in the world on many different levels. First of all, we're not being informed as to what's taking place in that courtroom. More importantly, though, the administrators of justice, be they lawyers, the judges, courtroom personnel, all of them, are not being watched. And when people are not being watched in a democratic system of governance, all sorts of bad things can happen. I always bore my students, so I'll bore you too, by reminding you with the tale of Bell, California. You all remember that little town? Tiny little California town where a Los Angeles Times reporter who, for some reason, got a tip from a tipster who was the cousin of I heard him tell the story, it was amazing, who said, "You ought to go check this out. There's some people making some god-awful amounts of money in this little bitty town called Bell." He said, "Bell?" So he goes and he starts poking around. And it turns out that the Bell, I think it was the city council, if I recall, had this lavish system of self-reward through what they called stipends for administrative work, right? You got X money for being a council person, which was almost nothing. But if you served on this committee and that committee, they would throw you a $3,000 stipend and a $5,000 stipend and then a $12,000 stipend. Turned out the city manager, by the point at which the LA Times finally got at the story, was making $1 million a year plus in public monies, right? This had been going on for the better half of a decade. And it started about this big. And it started with $1,200 stipends. But you know what? No one was watching, right? So the $1,200 stipends became $3,000, which became $6,000, which became $20,000. All the while, no one was watching. That's why when I see and hear of these anecdotal, singular, but cumulative examples of just no eyes on people, it terrifies me. Maybe it's because of the work that I'm doing, but I really do think it's terrifying. So that worries me. I'm equally worried by, at the same time that there are fewer eyes on the ground, there are fewer advocates on the ground than ever before. I was talking with a couple of my former students during the break, and I said something that's really worrying me right now is that the landscape of particularly FOIA, when we talk about open government law, of course, we're talking about a multi-tiered landscape. You've got the federal FOIA, and I sort of harken back to Adam's remarks. You've got adequate numbers of eyes and boots on the ground in Washington, and likewise, you got a lot of people using and litigating around federal FOIA, right? If anything, federal FOIA is being litigated to death, and that's an argument we can make also. But at the state and local level, what you're finding is that there was a fairly delicate ecosystem of organizations in and around the states that were created to make sure that governments were being open at the state and local level. As you can imagine, these groups were started by, funded by, and supported by the mainstream press. Well, we've talked all day about the de-evolution of the mainstream press, particularly the economic model, right? And so the groups that were founded to keep an eye on local government are in bad shape. I don't speak across the board, but mostly in bad shape. They have fewer resources and they have fewer volunteers than ever before. They've always been an all-volunteer army, by the way. There's never been, a professional class of FOI advocates out there beyond, well, the executive director of the FOIC, I guess, would have been one. But the states were all volunteer armies. So what I'm hearing from my friends in state FOI groups, many of which I helped start, is that they are down to 2 and 3 people, that their budgets, of course, have been slashed because the leading newspapers and television stations in their states have pulled out their funding. And meanwhile, the national journalism philanthropies, I think, have gone elsewhere for the most part. I don't begrudge them their willingness and their ability to spend money where they see fit. I just wish they'd spend a little bit more of it on the press freedom piece of the portfolio. We've got a lot of people out there these days highly enamored of digital whatchamacallits. And I'm a digital guy. I've got all the devices. I think digital startups are really cool, and we should be funding the future of journalism and all that stuff, but we should also be funding that which makes us able to do our work from a public affairs perspective, right? Several years ago, I was futilely making this argument to a potential funder who was quite literally looking over my right shoulder the entire time I talked to him, so I knew he wasn't terribly interested, but I thought it was a good analogy, so I'll use it again. I pointed out to him that a lot of funders these days are very interested in bullet trains. They like sleek, shiny, fast-moving things that are very beautiful. What they are ignoring when they ignore press freedom, when they ignore the FOI piece of this ecosystem, is the rail, right? The records, the meetings, the access to the data that makes all of those high-end journalistic whatchamacallits is freedom of information. It is press freedom. We're the rail. It's not very sexy. It's rusty right now. And they're putting gleaming bullet trains on it. And if they ignore the track too long, then I guess we all know what happens at the end of the line, right? I thought that was a great analogy. It didn't work at all. So maybe I shouldn't use it anymore, but I still think it's a really good analogy. The system of press freedom in this country is an ecosystem, and it's a very delicate one. It's been built by volunteers over many decades, many of whom are retiring out of those positions and out of those leadership positions in volunteer land, and they're not being replaced. And that's a reality, and it's a worry of mine, a great worry of mine. I'm also very worried, and I'll stop worrying in a minute, I promise, but I'm also very worried about the changing nature of media plaintiffs, or non-media plaintiffs, as the case may be, in FOI, both at the federal and the state level. I think what you can see, a few years ago, as just a sort of pilot academic study, I looked at the Department of Homeland Security for the first, I think it was 5 years of its existence, maybe 3 years of its existence, and I looked at every piece of litigation filed against its 34 sub-agencies. As you know, DHS is a monster, and there's a lot of litigation. So I just looked at every piece of FOI litigation that was brought against DHS in that 5-year period. And what I found began to worry me, even back then. And what I found was that media plaintiffs were almost non-existent in litigation against the DHS. Adam Happily, the New York Times, was still involved. The Washington Post was still litigating a little bit, and that was about it. You saw absolutely no other urban metro dailies as litigants. You saw no corporate chains as litigants. You saw no regional papers as litigants. You saw no television stations as litigants. What you saw instead were lots and lots and lots of NGOs. The ACLU, foremost among them. So what's so wrong about the ACLU advancing the cause of open government, you ask? Nothing. Except, I think it changes the nature of the game a little bit. Because, first of all, the ACLU's interests sometimes are hyper-legal. And that's a good thing if you're the ACLU. But media plaintiffs are always about access to the information for the sake of access to the information, right? The other thing that media plaintiffs do in the FOI context, both at the federal and at the state level, is bring with them ink by the barrel. We write about that which we do. So if the New York Times files suit and wins against the Department of Homeland Security, you can bet your bottom dollar that there are going to be stories before, during, and after. So DHS is getting beat about the head and neck for its secrecy, right? That may not make much impact on DHS. It does on state and local institutions. There was a day, actually when I got here in '98, I could bet that if there was a government agency in Jefferson City that was routinely flaunting the law, and it happened with great regularity, what was going to happen in a matter of time was that either the Star or the Post-Dispatch, often the Daily Tribune here in Columbia, would bring suit against that state agency, right? The Associated Press was very active in that period. So media plaintiffs were bringing cases which were bringing attention to the issue of openness in a major way. Nowadays, those media plaintiffs have just about exited the stage. And instead, what we see is an ecosystem in which NGOs sue, and then the media comes in and gets the records after they win. It's not, it's not non-ideal from an economic perspective, but it removes us as plaintiffs, us being the media. I've got to quit that, but it removes us from the landscape, and I think that's very harmful at the end of the day. It also worries me a great deal in when media plaintiffs' first concern, and I don't blame them, I'm just saying this is a fact, when media plaintiffs' first concern is the price tag of litigation, it should worry us all. It's not surprising. Litigation is incredibly expensive, fraught with risk, sometimes doesn't work out in your favor, and what do you have to show for it? You've got a large bill from an attorney, right? So it's not surprising that publishers across the country are making cost-benefit analyses in new ways when it comes to these pieces of litigation. But I'll give you a local anecdote to show just how difficult it can be to muster media plaintiffs these days. 5-6 years ago, I got a call from the Columbia Daily Tribune right here in our backyard from a reporter in a mad panic. There had been a Columbia police officer terminated from his job for excessive violence in an arrest. Upon termination, these records are routinely made public by Missouri state law. This is clearly a public record. And there's just no debate about it. However, somebody got really creative downtown, and while the reporter who made the request, by the way, and was told to come get the records, was walking to get the records, the Police Benevolent Association, or the Police Officers Association, I can't remember the formal numerology, but the Police Benevolent Association filed a temporary restraining order citing their collective right to privacy over that individual's records. It was a smokescreen. It was a legal, what would you call it? It was a legal rock throwing, basically. It had no merit. But all of a sudden, it became a legal entanglement, right? So conversations ensue, and it becomes very quickly apparent that there's some reticence, and this is not uncommon, but there was some reticence about whether or not to move forward because this could potentially be expensive, right? I'm begging them, going, you cannot allow this to stand. You've got to fight this thing. So ultimately, what we were able to do, the National Freedom of Information Coalition has an advocacy litigation fund that funds the costs, the associated costs of litigation, not attorney's fees, but the filing costs, copy costs, travel costs. Talked the Missouri Press Association's lawyer into handling the case if we got their costs. Jean Manke, bless her heart, came down. There was a 15-minute hearing in front of Judge Crane. He heard the argument. He went, get this out of my courtroom. The records were released to the reporter. Total cost, $142. Sometimes, you can imagine, down in southern Missouri somewhere, way up in northeastern Missouri somewhere, there are cases that aren't coming to light over $142, I guarantee you. Now multiply that across the entire country. That worries me a great deal. So those are my worries. Where's my optimism in closing? My optimism is probably threefold. First of all, I think a culture of transparency in this country is emerging in real time. The people are way out in front of their elected officials when it comes to what should be public. They want more. They're living in a digital age in which just about everything is available to them, and they're going to be increasingly demanding that as consumers of information. Secondly, news organizations and new institutions of accountability are emerging. If you go look at the Sunlight Foundation's work in and around Washington, D.C., I don't think you can help but be hopeful for the future. They are employing digital technology in radical ways to reopen government. So I am hopeful ultimately about the future, while I do, in Dean-like fashion, have a very long list of worries. Thanks.
Well, I am not a dean, so I'm not that worried about things actually. I think things are going to work out just fine. So, my topic is it's a little somewhat personal in a sense, in that I was fortunate enough in my previous life to have been able to get a job out of journalism school working with the editorial board of the Atlanta Constitution. This was back in, I guess, the 1980s, and part of my job was to edit the op-ed columns, and that's how I got to know initially Tony Lewis, and was through the columns that Adam mentioned, and I also did the other op-ed columnist, Reuben and know that, but also James Kilpatrick, known in the U.S. Supreme Court press corps, Jack Kilpatrick, and I really liked the fact that the two of them wrote about the law, Jack Kilpatrick and Tony Lewis. And my dream in life, as I was young, was to be an op-ed columnist writing for general interest publications about law, somewhere between Jack Kilpatrick and Anthony Lewis, shading over to Anthony Lewis, and I went to law school, to pursue that end. I was fortunate enough to get a job actually covering the U.S. Supreme Court, and I became aware of just how revered, that is the word that I can think of, but how highly regarded Tony was for all that he had done, and it wasn't long before I too wanted to be the next Tony Lewis. I think that everyone of my generation covering the courts, covering law, had that as their goal, was to be the next Tony Lewis. And I don't think any of us quite made it, but and I actually came quite close to my career goal, didn't make it. That's a good thing. I'm here now, thoroughly happy. But I do want to take this occasion to, offer a little bit of advice to the next comer. In other words, the next student. It could be somebody here in the room who wants to be the next Tony Lewis. And I say that not so much because I achieved that goal, but I can certainly see where, having seen and read Tony's work, having come to know Tony just a little bit, and having worked in the field, having a sense of what it's going to take for you to achieve that goal. So here are my list of my top 10 tips for doing this. As I have told my fellow panelists, this is a first draft. I actually only have 7. So I'm hoping that some of you out there might help me fill in the other 3. I think that I can probably do it, but I welcome your suggestions. So to begin with, one of the amazing things about Tony's writing was the sense of vision that it had. He was, and it could have been a product, it could have been a function just of the times, but he was so incredibly calibrated with the times, the changing of the country in the late 50s and early 60s, and his sense of attunement, for lack of a better term, with the times was extraordinary. And I think a part of it was that vision. Adam in his talk mentioned that he went to Harvard Law School for a year. It was a good thing for him to do, and that informed his vision. He had a really good appreciation of the fact that courts, while they may not be inherently political, or at least that's what we'd like to think, not inherently political, they do operate in a political environment, and he had that sense of political sensitivity that really informed his judgment. In other words, he understood that doctrine, that an important doctrinal decision was more about or had implications beyond doctrine to actually touch human lives. And he had a very strong sense of history. You can see that in his later writings, and that too informed his writing. He was writing against the backdrop of historical change that he was aware of and attuned with. And he also knew, as a part of his vision, that it's all about people. I think that if you've heard one sort of consistent refrain the whole day, is that when you're covering law, what you're really covering is people. I mean, it's about people. And he was the first real storyteller, quite in that way of what we would call in the trade humanizing the subject. So I would say my first tip is to cultivate that sense of vision. That it's not a narrow task; it's a broad task. And secondly, relatedly, is to remember that the story of the law again does begin with people. Now, Tony was especially good at bringing the parties into it, but it's more than just the parties. Somebody asked Adam during the Q&A for his session about why don't people write more stories about the justices? We don't have that kind of access and that type of thing. And the justices are people, and it's important as reporters for us to be aware of that. I have the good privilege of taking constitutional law with Jerry Gunther, a very now deceased, but very prominent constitutional scholar, and his constitutional law class really used to frustrate students because so much of it was just about him telling stories about the justices. And they were actually hilarious stories. Folks loved the class, but they just felt they didn't learn any law. And I asked him about it once. I said, why do you do this? He said, because these students, this was at Stanford Law School, he said, these students need to know that justices are people. And they may be working for these justices. They can't be in awe of them. And I think that's really, really important for a reporter covering these institutions of law, whether it's the courts, whether it's a legislature that's making law, an administrative tribunal. I mean, these people are people, and they deserve those people because we're going to be commenting, or at least reporting, observing, watching them. They deserve our best. So it's not just the parties; it's also the judges. It's also other people whose lives may be touched by these cases, and this is important. Journalism can be a very harsh profession. It really can be. I mean, the objective role is not always easy. It sometimes could cost friendships if not managed well. And one of the things that really comes through in Tony's writing is a sense of compassion. Now, that said, let me just be clear that when I say a sense of compassion, with Tony's writing, you could really see an appreciation for his fellow man, if you will. And in a sense, you could feel that appreciation beating, his heart through his writing. And it was why I think he was so aligned with the Warren Court, because that was about really the vindication of human and individual rights. It was a natural fit. I covered the court during the Rehnquist years, and this was during a time when those rights were being rolled back. Tony and I had lunch one day together at, I think it was at the ABA, and I said, it must have been a lot different covering the court during the Warren courts period. I feel like a pallbearer. You know, I call up people and I get to get their opinions about what happened in the case, and they're crying, they're in tears. With him, they were rejoicing. So, but I would say that you can't let your heart bleed. It's one thing to have one. There's one thing to let it get the best of you. It's quite something different. And I think both of those qualities are important in terms of having the kind of writing that will be compelling for readers, especially when you're writing about something that can be arcane like the law. Tony, as several of our speakers have noted, had an abiding respect for courts and for the rule of law. Some might say too much. I've heard it said that covering the Supreme Court is a little bit like covering the Vatican. And I think there's a little bit of truth to that in terms of lack of access and the majesty of the environment. I think a good reporter, to do the job well and effectively, has to get over that. And again, remember that we're covering people, we're covering important institutions, and that our audiences deserve our critical analysis. A related point, and my fifth of my seven, is to bring fire and passion to your work. But again, with some constraint, you can't opine with the justices. This, by the way, is probably the central critique of Tony Lewis. And when you get a chance to read the final written volume that comes out, you'll read a piece by Lyle Denniston that he first published in the U.S. Supreme Court Society publication, their regular publication. And I was told by the editor when I was working to get it that it's a little edgy. And of course, my first question is, how edgy can it be? It's the Supreme Court Historical Society. And it was edgy, because it made the point that Tony Lewis was not objected by any objective standards, and that he opined with the justices, that he let his own views influence of the correctness of the court's opinions, influence his reporting. And I think that as I was looking over some of his writing, I could see the critique. I think it's a little strongly worded, but I could see the critique, and so we've got to be careful. One of the first rules that I learned when I started covering the court was not to opine with the justices, and to let the justices be the be the judges, and for me to be the reporter. But that doesn't need to diminish the fire that we bring to it. We just need to temper it. My sixth point is to be relentless in pursuing the story. Tony was pretty dogged, and he was doing it the hard way. We've got, as you've heard today, incredible tools to be able to do reporting. That means we should be able to do it better. Let's do that. Let's be critical, and let's break through that veneer of the court. And when I say of the court, I mean plural. I mean the institution of the court, as well as law firms. We've heard about coverage of law firms today, as well as other areas of legal coverage. This so often is service in what is sometimes the most difficult sense, because it's not always fun telling hard stories. But that's so often what the community needs. I was talking with Alan Pusey of the ABA Journal last night about this, and to write stories about the difficulties that law firms are having right now. It's not always fun. It's hard to get that information. Nobody wants to to own up to the fact that it's challenging, but it sure is helpful to read about somebody else's situation. This is a challenge for us, and it's a very high calling to meet that challenge. And then my last point is this: to be kind and show your class in your work. There are some pretty sharp elbows out there in journalism. There are some really sharp elbows in legal journalism. You know, as they say in, well, certainly in Colorado and Washington, what goes around comes around. You know, I think that one of the things that truly set Tony apart was his class and the way that he dealt with people. The fact that he was willing to sit down to lunch with me when I was a Supreme Court reporter for you know, a local paper, really, not a statewide chain of papers, and to give me the time. There were times when I would call him up on stories, even though I was not his error, you know, at the New York Times. He gave me the time. He was that kind of person, and I know that there are a lot of other people who he helped in this way when he didn't really have to. And if you look at the people who are here, the reason that they're here is to honor him and what he did. We have a number of fabulous people who are going to be here next, who are going to be writing for this edition, including his former colleagues, Lyle Denniston and Linda Greenhouse, his successor, and others. And the reason that they want to do this is because of the kind of person he was. We're hosting this, and it's not because he was a jerk. It was because he was a class act. He did you know, important things, and he did them the right way. And you know, if we're lucky, at the end of our time, maybe somebody will have a festschrift about us in the same way that we do. It would only happen if we proceed with class. So I'm in the market for 3 more suggestions, and I look to you for help in that regard. So we have just a minute or two for a question, and then we'll take a break, and then we're going to rearrange the room, and then I'll ask all of our panelists to come down and take questions. So just 1 or 2 about these presentations, if they're already here. Yeah.
For Mr. Davis, we were talking about accountability and how sometimes in the courts there's no reporting at all when there maybe should be. Do you think that's in large part due to the economy, or do you think there are other factors in journalism that are steering away from that?
No, it's a large part of the economy. I mean, it's just a loss of boots on the ground over the last 10 years. It's been pretty dramatic. And so you can look at just about any news gathering organization and tell stories about how they once had a bureau of 5, now it's 1. They once had somebody in Jeff City, now they have a seasonal in Jeff City. You can go on and on and on, but ultimately it's an economic game. Yeah, I mean, as the news hole shrunk along with the advertising revenue, I guess in part it also became kind of a game as to whether or not you were going to pay the attention to public affairs journalism that you once did. And clearly there's a lot of argument going on in newsrooms large and small across the country right now as to what audience we're serving and how we serve them. And you know, my own little paper back in Athens, Georgia, where I live, has gone in an almost all digital strategy. Their staff has shrunk to, I don't know, 1/5 of its size. They're now very much about sort of local community happy news, for lack of a better term. How much of that is economic, how much of that is philosophical, I don't think you can trick out the two, really.
This is probably more of an observation from Mr. Davis than a question, but I can tell you that your worry about an absence of media plans going into court is more than justified. When I got to the Mercury News, one of the things that I loved about the San Jose Mercury News is there was absolutely no hesitation about sending in the lawyers when it even looked like we were gonna lose, just to send a message to these institutions that we're watching. And there was no holds barred on the amount of money, and we don't do that anymore. Pretty much, we only play defense. If we get sued, every now and then we'll go in joint with other news organizations, and kind of, this is the way, the sort of Costco way of doing it now, where we all share it. Or they just say, Mints, write a letter to the judge and see if it works. So I'm working pro bono. But I just wanted to share that, because certainly in California, that's very much the case.
I think it's true. The thing we didn't talk about, which is equally, okay, here's another worry, as these media advocacy groups are diminished in size and scope, you also have the legislative piece of the puzzle, which we didn't really have time to talk about. But very briefly, when I was running NFOIC, one of the things that I found really frustrating was you would have a proposed exemption to a public records law in the state pop up. And, you know, the phone would ring or the email would ping up, oh my God, man the decks, we have a fire in Indiana, right? And you would go, because it would be this proposed exemption that was horrific, that would basically gut the law. And over and over and over again, you found yourself fighting these fires. But back then, I had a fairly robust advocacy network to fight them with. I shudder to think what happens now. Because often those exemptions have sponsors, and those sponsors have industries behind them, economic development authorities, agribusiness. I mean, large, organized corporate spokespeople behind them. So when they go push an exemption, they've already got their ducks in a row. The media response historically has been to organize in real time, and we have the resources to do that. I don't think we do anymore. And I'm already starting to see some really, I saw 2 or 3 exemptions pass this legislative season, and I've been a little distracted, but I've paid some attention to it, and I've already seen a couple of exemptions that I can guarantee you would not have passed 10 years ago, because there would have been sufficient hell raised over the quality of those exemptions and the logic behind them. They would have played out in editorials across the state, and they would have been beaten down. That infrastructure it's rusty, to say the least, and that keeps me up at night.